Please. Good afternoon, everyone. They say the post-lunch session is the hardest. Don't worry, we have very strong coffee and a very exciting panel with us today. It gives me great pleasure to welcome you all to session 3 of the Delhi Arbitration Weekend 2025. We are gathered here in the historic precincts of the High Court of Delhi for a conversation that goes to the very core of arbitration. The topic for this session is Appointment of Arbitrators, Party Autonomy Conundrum. Party autonomy is often described as the cornerstone of arbitration. It allows parties the freedom to decide who will hear their disputes and how their arbitration will be conducted. This freedom is what distinguishes arbitration from court litigation and is the reason arbitration has become a preferred mode of dispute resolution. But that autonomy is not without its challenges. Too much discretion in appointments can raise questions of bias or impartiality, while too many restrictions risk undermining the very essence of arbitration. The conundrum lies in striking a balance between respecting the choices of parties and safeguarding the integrity of the process. It is in this balance that forms the heart of today's discussion. To discuss this, we are honored to have an exceptional panel with us. Our chair for today's session is Honorable Mr. Justice J.K. Maheshwari, Judge of the Supreme Court of India. Justice Maheshwari has served with distinction on the bench. Justice Maheshwari has served with distinction on the bench and brings with him the experience of having presided over significant constitutional and commercial matters at the highest court. Justice Maheshwari has authored various important judgments that have had a deep impact on the arbitration jurisprudence in India, including the interplay between Section 9 and Section 17 of the Act. Before his elevation to the Supreme Court, he served as the first Chief Justice of the newly established Andhra Pradesh High Court and later as Chief Justice of the Sikkim High Court, where he played a key role in strengthening judicial institutions. Please join me in welcoming Justice J.K. Maheshwari once again. Our next panelist is Honorable Mr. Justice Anand Pathak. Justice Pathak is a judge of the High Court of Madhya Pradesh. Justice Pathak was appointed as a judge in the year 2016 and was confirmed as a permanent judge in 2018. Justice Pathak has served with distinction on the bench, dealing with a wide range of cases, including arbitration and commercial disputes. His judgments on arbitration, and in particular, have been extremely instructive and enlightening. His judgments reflect a careful balance, maintaining a hands-off approach to arbitral autonomy while stepping in where necessary. This perspective on the issue is significant in developing arbitration jurisprudence in India. Please put your hands together for Honorable Mr. Justice Anand Pathak. Our next panelist is Professor Maria Chiara Malaguti. Professor Malaguti is a highly respected academic and international lawyer. As the first woman to lead UNIDROIT, she has guided the organization's work in harmonizing and modernizing private and commercial law across jurisdictions. Her career spans both academia and practice, and she is recognized globally as a thought leader in international law as well as arbitration. Please welcome Professor Malaguti. We also have with us Mr. D. Seshadri Naidu, Senior Advocate. Mr. Naidu has decades of experience. He was a former judge of the Andhra Pradesh High Court before donning the role of Senior Advocate and has been arguing extensively before various courts and tribunals in India. His career is marked by his deep involvement in arbitration and litigation alike, and he is known for his clarity of presentation and practical insight into dispute resolution. He brings with him a perspective of a former judge and a seasoned practitioner who has seen arbitration evolve closely over the years. We welcome you, sir. Last, but certainly not the least, we have Ms. Sapna Jhangiani, King's Counsel, Barrister at Blackstone Chambers. Ms. Jhangiani is an accomplished international lawyer and King's Counsel with a practice spanning Asia, the Middle East, and Europe. She has acted in some of the most complex cross-border disputes and also sits as an arbitrator in most of them. She is recognized as a leading figure in international arbitration community and brings a truly global perspective to this panel. Please join me in welcoming Ms. Jhangiani. With such a distinguished panel, this session promises to be rich and engaging. It is now my honor to invite our chair, Honorable Mr. Justice J.K. Maheshwari, to open the session. Please.
Good afternoon, everyone. After this post-lunch session, I wholeheartedly welcome all of you to this celebration of the arbitration in New Delhi, a city spring of becoming a global dispute resolution hub. Arbitration charms lies in its promise, swiftness, and certainty, guided by the fundamental principles of the party autonomy, which is the topic of today. The freedom to choose your own expert adjudicator, to tailor the procedure of the nature of dispute, and to create a bespoke process that is both efficient and intelligent, ensuring that the commercial disputes are decided by commercial minds. India's legal landscape has decisively shifted to a pro-arbitration stance, with courts respecting the competence principle while also steadfastly protecting the impartiality of arbitral tribunals. Achieving the shared goal of establishing India as a vibrant arbitration hub now requires a concentrated and collateral effort from all stakeholders in this field. Nevertheless, questions persist regarding the appropriate scope of judicial intervention in the arbitral process, must critically at the stage of constituting the tribunal. The topic of our sessions today address this very challenge, the inherent tension between the sacrosanct principle of party autonomy at one hand and the imperative of party equality, independence, and impartiality on the other hand. Even though the arbitration clause contained in a contract might be a manifestation of the party autonomy, how far it might be justified if court finds that it militates against impartiality and independence of the tribunal and party equality. Therein lies the conundrum. Since difficult choice is cast upon the national courts and arbitral institutions, should they uphold the sanctity of the parties' contract, even if leads to the procedurally skewed process, or should they intervene to protect the fundamental fairness of the arbitration, thereby overriding the expressed will of the parties? Our eminent panelists, who are subject matter experts, will deliberate on this issue. It is my experience that answers to life's most complex questions often lies in the return of fundamental truth. While today's discussion may not resolve this age-old tussle, our goal is thoroughly analyze the key conflicts that arises globally and varied approaches courts take to resolve them. While party autonomy allows disputing parties to select their arbitrators, ensuring efficiency and trust in process, this freedom must be balanced against safeguards that prevent conflicts of interest and protect the integrity of arbitration. The role of arbitrator in an arbitral proceedings is akin to that an empire. Every decision taken by arbitrator contributes to the final award. Their neutrality and fairness is fundamental to the process, and so the act of appointing an arbitrator must be just and fair. It is for this reason that it is wrong to say that party autonomy is not absolute, as it must necessarily operate within the framework of legal and ethical constraints that preserves the integrity and legitimacy of arbitral process. Fundamental principles of law, such as due process, right to be heard and equal treatment of parties, along with public policy considerations, act as balancing force which tempers party autonomy. As arbitrator derives their authority from a contract, this makes the framing of such contract critically important. In the practice, both in India and globally, contracts are often drafted by the party with greater financial strength and bargaining leverage. This imbalance frequently manifests in the clauses that grant one party exclusive control over the appointment of the arbitrator. Such arrangements raises the legitimate concern, particularly when the appointed arbitrator is an employee of or otherwise affiliated with the appointing party. The challenge lies in striking a delicate balance between the freedom of parties to appoint and the imperative of independence of the impartiality. Achieving this balance requires a collaborative effort through thoughtful legislative reforms, nuanced judicial interpretation, and the active engagement of arbitration fraternity. The lawmakers in India attempted to draw a fine line between ensuring the independence of arbitrators and preserving party autonomy in their appointment through the 2015 amendment to the Arbitration Conciliation Act 1996 by adding Section 12(5), which works hand in hand with Schedule 5 and 7 of the Act. Section 18 of the enshrines of the non-derogative principle of the party equality, which
In context of appointment of arbitrators and subsequent fallout under Section 34 and 37 of Act. Arbitration brings confidentiality, brisk pace of litigation, and inherent flexibility. By party economy, party is free to select not only substantive law, but also the procedural framework, the arbitral forum, and composition of the tribunal. Party may choose the number of arbitrators, their qualifications, and even the appointing authority. They can also opt for institutional rules such as those of ICC, Singapore ICC, UNCITRAL, or develop tailor-made mechanism as per the nature of their dispute. The foundational concept of party autonomy is allowing the party to select the governing law, procedural rules, seat of arbitrator, and the composition of arbitration tribunal. But now the conundrum comes. If the issue is seen from the Indian perspective, it is to be seen from dispute between two private entities or arbitration agreement in public-private dispute. So far as private contracts are concerned, party autonomy at times compromised because sometimes other side is borrower, licensee, or not in a position to assert when the agreement is signed. We are talking about institutional arbitration, we are talking about corporate arbitration, but some of the cases are like housing and vehicle loan finance companies, where one-sided arbitration agreements are prepared, and seat of arbitration, composition of arbitration, rules of arbitration are such which make a person at the receiving end. This compromises autonomy of an individual since inception. Another situation is public contracts, where government or its companies agreed to settle their dispute with private contractor through arbitration. As Justice Maheshwari has referred in Code 2, that is Central Organization for Railway Electrification versus ECI SPIC, reported in 2025 for SCC, held as per majority view that every action of public authority or person acting in a public interest or any act that gives rise to public elements must be based on the principles of fairness and non-arbitrariness. Section 12, subclause 5 of the Arbitration and Conciliation Act has also been discussed. Conclusions are like this. The principle of equal treatment of parties applies at all stages of arbitration proceedings, including the stage of appointment of arbitrators. The Arbitration Act does not prohibit PSUs from impaneling potential arbitrators. However, an arbitration clause cannot mandate the other party to select its arbitrator from the panel curated by PSUs. A clause that allows one party to unilaterally appoint a sole arbitrator give rise to justifiable doubts as to the independence and impartiality of the arbitrator. Further, such a unilateral clause is exclusive and hinders equal participation of the other party in the appointment process of arbitrators. Next, in the appointment of a 3-member panel, mandating the other party to select its arbitrator from a curated panel of potential arbitrators is against the principle of equal treatment of parties. In this situation, there is no effective counterbalance because parties do not participate equally in the process of appointing arbitrators. The process of appointing arbitrators in Core 1 is unequal and prejudiced in favor of the railways. Unilateral appointment clauses in public-private contracts are violative of Article 14 of the Constitution. The principle of express waiver contained under the proviso to Section 12(5) also applies to situations where the parties seek to waive the allegation of bias against an arbitrator appointed unilaterally by one of the parties. After the disputes have arisen, the parties can determine whether there is a necessity to waive the nemo juxis rule, and the law laid down is to be applied prospectively. However, Justice Narasimha has, while giving opinion separately, has reiterated the necessary distinction between the duty of the parties to arbitration agreement to constitute an independent arbitral tribunal and the duty of the arbitrator to act judicially and judiciously. This is one of the important aspects. This comes regarding impartiality, independence, integrity of an arbitrator. Although the judgment delivered in Core 2 discussed about former aspect, however, about the duty of the arbitrator, which equally important to give validity to the very concept of arbitration. Therefore, when the question of justifiable doubts arise about arbitrator and his impartiality, independence or integrity, then that has also to be seen. Concept of party autonomy includes impartiality and independence also. Because different forms of bias can be found in arbitrator, like confirmation bias, conformity in bandwagon bias, authority bias, anchoring bias, framing bias, loss aversion, and status quo bias, self-serving bias. To address those biases, some tools of psychological integrity assessment can be applied. Structured pre-appointment scheming, reference and track record check, rotating first speaker and equal airtime, calibration exercise, self-audit, and disclosure rigors can be looked into. Even at times, arbitrators may be excellent, but they may not be knowing their own biases. Therefore, psychological training sessions or value addition workshops can also be designed for arbitrators and can also be thought of. Another aspect about the duties of arbitrator is regarding training. If arbitrators are trained and their skill may sharpen regularly, then their independence and objectivity would reflect in awards, and the parties would not go in appeals once award is passed. In the case of DIAC Technologies, as referred earlier, Supreme Court set aside the award because the award was unintelligible and bereft of adequate reason. Since arbitration is intellectually driven process, therefore requires assimilation of rival thoughts, meticulous churning, and reproducing it in the form of judgment dealing rival submissions. This training is necessary to avoid kitchen sink approach. For example, in California, arbitrators are given training to act as passive arbitrators throughout the proceedings, whereas in Vermont, arbitrators are permitted to be inquisitorial. Therefore, while discussing party autonomy conundrum, one has to think about rights of the party to constitute independent arbitral tribunal vis-a-vis duties of the arbitrator to act judiciously and objectively. I thank the organizers for giving me invitation, and I thank the audience to give me patient hearing. Thank you very much.
To put the Indian perspective, I will request to Mr. Seshadri Naidu to have their views here.
Good afternoon. In the last about 5 years, my day begins with and ends with the word, "May it please your lordships." Now, I need to change that today. I do change it. My Lord, the Honorable Justice J.K. Maheshwari, my co-panelists, Honorable Sri Justice Anand Pathak, Professor Maria Chiara Malaguti, and King's Counsel, Ms. Sapna Jhangiani. I requested Madam to know how to pronounce that. I hope I did that in the right way. The Honorable Chief Justice of Delhi High Court, and all other companion judges of His Lordship, and the judges from other high courts, and the meticulous team of the organizers of this Delhi arbitration weekend, the scholars from across the world, all the academicians, the learned professional elite, my colleague lawyers, and fellow students, my pranams. The topic that's been given to me, or to all of us, is appointment of independent arbitrator, party autonomy conundrum. And what would be the scope of our discussion? But certainly the topic is very interesting and intriguing. It has got two words that set me thinking. One is autonomy, and the other one is conundrum. Why? They don't gel together. They're oxymoron, one opposing the other. When you have an autonomy, it is clear, straight, and non-negotiable. A conundrum is always a riddle that throws everything into doubt. So let's resolve it if we can. The Honorable Chair, in one of our informal discussions, all panelists together, gave us a route map for the discussion. His Lordship has said, how much freedom do parties retain, and to what extent must they yield to impartiality safeguards in the face of Section 12, subsection 5 of the Arbitration and Conciliation Act? And the other one that's been said is, in cases where an arbitrator was unilaterally appointed, but no challenge was made during arbitration, should courts allow setting aside awards on such grounds at the post-award stage? What should be the policy consideration balancing procedural finality with fairness? These are the ones that have been said. Some say, if you talk about law and you don't refer to Lord Denning, it's a sin. And some say, if you're talking about literature, if you don't refer to Shakespeare, it's again a cardinal sin. And we do talk about law, but still I would like to invoke Shakespeare, the bard, the brilliant bard at that. In Hamlet, he has said, that's in Act 3, Scene 1, and we all know perhaps the most quoted one, to be or not to be. And here, to choose or not to choose. Our own arbitrator. And by removing or replacing a couple of words, I'll present that couplet before all of you. To be or not to be, that's the question. Whether it's nobler in the mind to suffer the slings and arrows of outside selection. I've replaced the outrageous fortune with outside selection. Or to take proceedings against doubts of bias and end them by choosing our own arbitrator. Only 2 words have changed, the rest remains the same. A man for all seasons, perhaps he is. Now let me go back. Let me come to this conundrum. Why has this been termed a conundrum? I reckon it's on the basis of perhaps bias. Because the bedrock of adjudication of whatever nature, whatever hue, color, is impartiality. That's why they have said justice should not only be done, but must be seen to be done. Not seem, seen to be done. When that is the case, how can we talk about justice if somebody imposes on us a judge? It's not the statute, mind you. We have to remember, it's not the statute, it's another party, your rival. He imposes, be in the name of panel or whatever nature. So in that context, now let me put a question to myself. It's a lawyer jargon, I do agree. What is justice? If you read Francis Bacon's one of the finest essays on truth, the very first sentence in that is, what is truth? But Pontius Pilate did not wait for an answer because he knew there was no answer. Who is this Pontius Pilate? The Roman revenue official or judge who tried Jesus. The one who crucified Jesus, not because he found him guilty. He did say that he was not guilty, but because the public prayed for his blood. Otherwise, things could have been, rather, history could have been different. Now, if I also quote another person with regard to justice, that is Oliver Wendell Holmes Jr. An interesting episode. You may have heard about another name called Learned Hand. What a name. Learned Hand was the circuit judge. That means circuit in the sense something like our High Court. They had about 13 circuits. A circuit judge. And always it's been said, the finest Supreme Court judge of USA that had never been. This Learned Hand. And when he was a law clerk, he finished his court session in Supreme Court of the USA, and he was coming out. Then he saw Oliver Wendell Holmes going home by his car. He requested, "Sir, could I have a drop?" He said, "Yes, get in." So he took him along and dropped him at the place where he desired on the way. And this young, enthusiastic Learned Hand, later a legendary Learned Hand, incidentally has a distinction, perhaps the second most quoted American jurist, Learned Hand. And he said, "Dear Justice, please do justice." He waved his hand and said, "Dear Justice, please do justice." Then he backed up. Oliver Wendell Holmes Jr. backed up his car. "Young man, what did you say?" He said, "I didn't say anything offensive, sir. I only said, 'Dear Justice, please do justice.'" He said in his classic way, "That's not my duty." There lies the catch. So, does an arbitrator do justice? He has no Section 151 of CPC. He has no Article 226. He has no Article 142. But can we imagine any dispensation of, decision, adjudicatory, without an element of justice? Here comes the importance of having people without bias. Now, let me think of the choice we are talking about. there is perhaps some problem when it comes to the cross currents internationally. Of course, I'm not going into that international jurisprudence, internationally, because let's take the common law doctrine of bias, which has not been codified. The common law doctrine of bias says that if you can't be a judge in your own case, and if you have any sort of interest, it could be pecuniary bias, it could be whatever sort, you cannot be a judge in a cause. You know, it originated perhaps in the common law began essentially 1066, when William the Conqueror came over, being the Norman king, and then consolidated the whole England, or the UK as we call now. Then he imposed that everybody should have the same law. And that's how it's become common across the country. It's become common law. In that one, being a small society, this bias principle worked. Because everybody knows every other person. Then that element is there. But when it comes to a country like India, with teeming billions, rather millions, 140 crore people. Let me assume, if you read Schedule 5 or Schedule 7, what's been said? In one, there are 34 instances, the other, about 19 instances of bias, or likelihood of bias, that disqualifies the arbitrator. Let me assume, even in the daily parlance, many of you could have seen that there is a mighty corporation, and that corporation, a learned judge, or for that matter, an arbitrator, may have 100 shares in that one, worth 10,000 rupees. Should he recuse? If he gives a decision in favor of that company with 10,000 rupees stake in that one, how much is he going to get? 10 paise when there is a dividend? So perhaps what applies to small societies, that's my humble endeavor, what applies to small societies may not apply to Indian context. That said, how about the autonomy of a party? You know, when the whole premise of Arbitration and Conciliation Act, let me put it in arbitration terms, is the contract and the contract alone. And that contract provides certain way of going forward with regard to adjudication by choosing a particular person or persons to be the arbitrators. Then until Section 12 suffered an amendment, the Indian presidential position was that there should be fidelity to contract. And if contract dictates and you have signed that with your eyes open, wide open, you cannot wriggle out of it by taking a zany proposition like bias or lack of independence on your part. Thereafterwards, Section 12, subsection 5 came into picture. Then the position has changed. And now that stands confirmed by a constitution bench in course case, Central Organization for Railway Electrification. I just will have a couple of minutes on each of these decisions. But before that, because why I'm saying that one is this. Precedents are bound to change because law is evolving. And when it evolves, in my earlier avatar, I used to tell young lawyers that don't heavily rely on the judgments. You know the difference between style and fashion. Fashion is ephemeral or quite changing. Style is eternal. Statute is style. Judgments are fashion. They're bound to change because we have a different pattern. Mind you, Constitution is vaguely, rather designedly vague, so that it can cater to changing needs. Here, precisely, in core, there is a jurisprudential experiment. What's been said is, when it comes to the choice of an arbitrator, if it's been imposed, it offends the principle of Article 14. The constitutional doctrine has been brought into. Can it be? My lord, what I say is, it is a seminar. Seminar has the Latin root of seminarium or seminus. Seminarium means seed pod. Then seminarus is the seed. So we are not talking about the presidents or causing an offense to a president by talking in contradistinction. I am only trying to have a seed planted, if I could in my humble way, so that there could be discussion. In that way, my proposition is this, before I go into the decisions. My proposition is this. Constitution across the world, when they have written constitutions, work in two ways. One is vertical, the other one is horizontal. For example, until recently, criminal law is vertical. It has never thought of the victim. You only have to see the society, that is the state, and the offender, the accused. It's vertical application of criminal law. Then now victim compensation, victim rights, etc. The pioneer in this field was South Africa. They've had now put it horizontal. We do. And when it comes to constitution, it is the limitation on the power of the state. When it is the limitation on the power of the state, it is vertical. Barring a few changes like Article 17, untouchability. Then other ones like forced labor, bagar and other things. Barring these things which have been horizontal, the rest of Indian constitution is vertical. And I am told, subject to correction, German constitution is horizontal. So in that context, can we import essentially chapter 3 into private contracts? It's a debate. Once the same issue, if you look in a different way, with the unequal bargaining power of between the two contracting parties, the state assuming to be one of the contracting parties, imposing its own panel or individual lawyers, or individual arbitrators to be chosen from. They may say that we have a panel. It's a Hobson choice for you. Even panel of 5, you have to choose one among them, not your choice. So on that count, it's unconscionable. You have a weak bargaining power. So it can be struck down on the common law principle. If at all, we could think of not applying, say, like Article 14. But still, it's evolving. Who knows what could be the final word? There cannot be a final word. Now let me come to the decisional front. The first one before, or rather the prominent one before, the amendment was Newton Engineering and Chemicals Limited. In that case, the IOCL, being one of the contracting parties, stipulated that the executive director must be the sole arbitrator. By the time the dispute came to the hustings, that post was abolished. And a sort of an impossibility, and the doctrine of necessity was invoked. And it's been said an equivalent post or some other one could be the arbitrator. An arbitrator was chosen and appointed. That was challenged before the Honorable High Court. The High Court negated that one. Then it's been taken to the Honorable Supreme Court. Supreme Court has held you should have fidelity or faith to the terms of the contract. Once it is an ED, executive director, he is not available, that's the end of it. Then it stands frustrated. And interestingly in that one, what's been said is, you better take recourse to civil court remedy. Not that we are appointing or somebody is appointing. The Honorable Supreme Court has said, you'd better have civil court remedy. Now let me come to, after amendment, perhaps one prominent judgment to begin with could be this Westerfine. 2017 it was rendered. Again here, the party challenged the other party imposing an arbitrator on it to be the sole arbitrator. When that was challenged, the Supreme Court has taken a literal approach. And having taken a literal approach, said that one, you should have that one. That's been said. And also they have said that once it's been an accepted proposition, you're stopped from wriggling out. Then came the next one, and also they have said one more thing. It's a panel of highly qualified, experienced panel of engineers who had been suggested to be the arbitrators, and you cannot accuse them of bias. Maybe a noble one, an ideal one, but this is not an ideal world, unfortunately. Then came TRF case, that was 2017. And in that one, it was the case of sole arbitrator. They've said that you cannot impose an arbitrator, whatever be the justification. Perhaps that's the trend that has begun on a different leaf. Then came Perkins case of 2020. That has echoed the same principle and said it is non-est. And the principle of coram non judice will apply, whatever the proceeding that have happened up to that point. And the icing on the cake came in 2024, that is core case. In core case, a constitution bench of the Honorable Supreme Court has held, confirming both Perkins and the TRF case in more elaborate manner. But here comes the question of Article 14. Yes, it is a seminar. It is time we pondered putting our heads together. I thank the chair. I thank all of you for this opportunity. Thank you very much.
Thank you, Ramaji. Just for the international perspective, I request Professor Maria Chiara Malaguti to address the gathering, please.
Thank you. I'm really honored to be here, and I thank all the audience and those who invited me. I'll try to speak as slow as I can, because I know that I have a strong Italian accent, so I'm trying to make you understand me. And I'll try to take you into a sort of short international journey. My contribution here could be, of course, I will tell you a few things on the Italian legal order, just to give you an example of a civil law country addressing your questions. But if you allowed me before that, I will try to take you inside the room of the negotiations that we are having now at UNCITRAL, so not UNIDROIT, but UNCITRAL. This morning, UNCITRAL was mentioned for the model law, but we also have another working group, and some in the audience are part of these negotiations where I represent Italy, on investment arbitration. So I move for 1 second to investment arbitration, because over there is a debate. And we adopted at some point a code of conduct on independence and autonomy of arbitrators. Why I go there? I go there because I believe that the title of this panel is one of the most relevant issues that we need to discuss in arbitration. Why? Because arbitration at the origin was indeed 100% based on parties' autonomy. And the origin of arbitration was a private way to solve issues. Still now, if you go to a construction arbitration, you use, for instance, the FIDIC rules. As it was told you in the morning, you might have arbitrators that are not even lawyers. It is a community deciding on the basis of standards that they have self-elaborated. The origin of arbitration is the same if you look at financial markets and the way people judge on those specific issues. But today, we use arbitration for many more cases. We open arbitration also to small and medium-sized enterprises. We use arbitration also in other fields of law. So now we are indeed at the crossroad, at a point where we do discuss whether arbitration is still the way it was originally. And again, now I go to investment arbitration. You know, and if you don't know, I'll tell you that the main scope of work of that working group is to decide whether we want to have an international court taking care of investment arbitration to protect some general interest of states in those cases, or we improve arbitration as a system. And we have two parallel tracks. And my take is that wherever we go with those negotiations, the very fact that some member states want to have an international court oblige those who believe in international arbitration to institutionalize the arbitration as much as possible and to make it similar or closer to court methodology to protect some of the general principles of protecting rights. Those in the audience who are part of the working group will tell me whether they agree with my understanding. But what I see as a real political underground message is that somehow, even if we never go to an international court, we do strongly affect parties' autonomy in arbitration through those works. One of the less evident ways we do so is indeed through independence and autonomy of arbitrators. Why? Because we discussed for months what an arbitrator should, how an arbitrator should be, what independence is, what autonomy is, whether an arbitrator can also be a counsel in a case, the famous theory of the double hatting. We tried to make some standards mandatory. The debate was strong. There was also strong opposition by the very community of arbitrators, saying that they could not be trapped in something that is outside the logic of arbitration. Again, go back to the community story I was telling you. The reason why, at the origin, a good arbitrator was selected was exactly saying an arbitrator which has a lot of experience, an arbitrator who knows the community, a friend of us, someone who knows all the details of the community, someone who's part of the community will be the one judging on that specific dispute. So the original logic was indeed exactly because I'm part of the community, I will be a good judge in the sense of an arbitrator. If you start with all these elements of independency, autonomy, no double hatting, you basically are creating an understanding of an arbitrator that is closer to a judge than an arbitrator in the original way. However, in investment arbitration, we went there. we had a code that applies to institutional arbitration, ICSID, or to ad hoc arbitration, because the UNCITRAL rules are for ad hoc arbitration. However, all of this said, it is a soft law product. It is just a code of conduct. What does it mean? It means that parties might decide to modify some of the rules, at least in an ad hoc arbitration. Somehow the way these principles apply might vary according to the agreements, but of course there is a trend. So it becomes an international standard, a benchmark to be used. We discussed for months possible sanctions. We were unable to find agreement on sanctions if you do not respect some of these principles. So it is said that sanction will be decided in any other instrument that applies the code of conduct. But now let me go. So we do have this product. It applies to investment arbitration, so specific. It is a soft law instrument. It is, in my understanding, a trend in any event of the way arbitration is considered. But now let me go quickly to Italy. And you see how the two things might be connected. In Italy, we had a big reform for arbitration in 2022. Before that reform, arbitrators could not adopt any interim measure, not emergency measure. That was prohibited. You would go to court. After 22, now arbitrators can adopt interim and emergency measures. And all the reform is based on parties' autonomy. So, answering the question, can one party unilaterally appoint an arbitrator? No, 100% no, because parties' autonomy means agreement between the parties. Parties might reach some sort of agreement where an extra power is given to one of the two parties, but only if there is no abuse of right, or so the two parties are balanced in power, and they do agree to a mechanism that permits that. However, in Italy, we do not only have general arbitration. We have, for instance, company arbitration. If you have a clause in the statute of the company permitting arbitration, then you can have an arbitration for some company issues. On that, there are specific rules that permit unilateral appointment and the choice of the arbitrator by a third party, by a tribunal. So the general rule is no unilateral mechanism, but still some exceptions in some specific field of law. For the other issue on limits in who can be an arbitrator, we only have one mandatory rule, which is you need to have legal capacity. If you don't have legal capacity, you cannot play as an arbitrator. For the rest, there is no other rule that impose to the parties, so that limit parties' autonomy. So what is the mechanism of protection? True set aside. If the parties agree not only on the arbitration, but also on the result of the arbitration, so in the cases that we said are normally the rule, the award is safe, whatever the arbitrator was or whatever he did, whether he was independent or not, if the parties agree, the award stays. There is no possibility inside the mechanisms of arbitration to challenge. However, if it goes to court for any sort of clearing, let's say, in that case, you can set aside an award for domestic arbitration, basically for the kind of mandatory rules that I saw in your legislation. In Italy, the language is a bit high level, but looking at them, I tried to put them together one after the other, and I would say that all cases that you cover would possibly be covered also by the Italian Code of Civil Procedure. It is completely different if you go to international arbitration. When you go to international arbitration, you apply the New York Convention as, because Italy ratified the New York Convention, and for that, the only real protection is public order or public policy. And public policy is applied restrictively in Italy. So all what I said would apply only if there is an evident abuse or an evident violation of law. So party autonomy is kept with the big possibility of setting aside the award if there is a clear violation of public order or public policy. However, I conclude with one thing that I didn't mention on the code, but that might be something to consider, which is disclosure by the arbitrators. Not only the arbitrator must be independent, autonomous, not have any conflict in terms of double heading, but it has to disclose all of these information. Now I conclude mentioning a case which many of you might know, because for those who work on investment arbitration, at the very least, you might know, which is the Rockefeller case against Italy. I'm counsel to Italy for all investment arbitration, so I'm not going to go into details, but you might know that it's very rare that an ICSID award is annulled. That one was annulled for improper constitution of the tribunal, because one of the three arbitrators was found in breach of the criteria of the standard for arbitrators. Now, if you read that case, you see that the real point was not whether it was in fact non-independent or non-autonomous. At ICSID, there is also a standard of moral standing. So the ad hoc committee was very strict in analyzing these criteria, but the award was annulled because the arbitrator had not disclosed the facts. So the matter was, if the arbitrator discloses, if you know the cases, then the situation, then again parties' autonomy is protected in the same sense that if you are okay, you can go on also if you find that this arbitrator lacked one of the standards. The only question that we, the Italian team, asked itself, had we gone to an Italian tribunal to see whether this award, we could not with ICSID, with ICS convention, but assuming that we could, in that case, would that lack of disclosure be a sufficient element for violation of public order? So would this criteria of set aside work in that situation? I have no answer for you. It might be not, possibly, for the specific situation of the case. But again, the real point is trying to find a balance between saving and protecting parties' autonomies, but still trying to ensure the general principle of arbitration, to make arbitration closer in terms of protection of rights of parties to what a court asks. So you see, the international debate, I would say, is addressing exactly what you are addressing in India, probably through different channels, but I think it's really something that I'm honored to discuss with you, because this is really something for the future understanding of arbitration. I hope you understood what I said, and thanks a lot.
Thank you, Professor Malaguti. Now, I request Ms. Sapna Jhangiani to have their perspective on the international arbitration, please.
Thank you very much, sir. With your permission as Honourable Chair, that of my co-panellists and the audience, I'm going to share my thoughts from here. One of the features of international arbitration practice is that we present seated. So that's, I suppose, an upshot of having practiced predominantly international arbitration for the last 25 years. So I'm going to cover a little bit of the foreign perspective on this conundrum that we have, and then I want to spend a little time looking at the conceptual framework of this issue, picking up on the points that have already been made by all of my co-panelists on the concept of party autonomy. And my starting point is the core judgment that we have, of course, heard so much about today, such an important piece of jurisprudence, not just because of the very well-reasoned majority judgment, but also the very thoughtful dissenting judgments that we have. And I will be borrowing from Justice Narasimha's dissenting judgment in that case, where he very helpfully set out foreign cases and foreign legislation that deal with this issue of unilateral appointment of arbitrators by one party contained in an arbitration agreement. So if I start with the legislation, as pointed out in that dissenting judgment, certain foreign legislation, such as in Spain, Germany, and Estonia, provide that a party may request a court to make an arbitral appointment if one party has an unfair advantage in the appointment of the tribunal. So we have statute providing for this scenario and essentially giving the party an opportunity to stick with the agreement or to go to court to find a different arbitrator. There's a European convention providing a uniform law on arbitration, which states that an arbitration agreement is invalid if it gives one party a privileged position in matters of appointment. Justice Narasimha also went through several cases spanning France, Switzerland, the US, and the UK, and I'll just briefly touch on each of those cases. Now, France is famous for having a very liberal approach to arbitration, so some of us may not be surprised that the Court of Cassation in France had no difficulty whatsoever upholding an arbitration agreement where one party provides a list of potential arbitrators from which the other party must choose an arbitrator. But all the other cases that have been cited by Justice Narasimha form a contrary view. So if we look at a Swiss decision that he cites the Federal Court of Cassation in Switzerland as saying that the most important principle and safeguard in arbitration is that no party may have a preponderant influence on the appointment of the tribunal. We then have several American cases, that very famous American restaurant Hooters that some of you may heard of, quite a controversial restaurant, now contributing to arbitration jurisprudence, you'll be happy to know. In the case of Hooters of America, there was an employment dispute, and Hooters was given exclusive control over the panel of potential arbitrators from which the other party could select the nominee arbitrator, and that clause was held to be against the rules of neutrality and was struck down by the courts in Massachusetts. We have a decision of the District Court of Maryland holding an arbitration agreement to be unconscionable because the arbitrator was selected from a list of potential arbitrators curated by one party only. The line of cases continues. We have another case, McCullen and Mayer, where the court noted that when the process used to select the arbitrator is fundamentally unfair, as in this case, The arbitral forum is not an effective substitute for a judicial forum, and there is no need to present separate evidence of bias or corruption, because in that case, one party was again granted exclusive control over the pool of potential arbitrators. So you don't need evidence of bias, there's assumed bias. And we had some very interesting points made by Justice Pathak about all of these inherent biases we have. I don't know if many people in this room have read Daniel Kahneman's book, Thinking Fast and Thinking Slow. There are so many biases we have. Even if an arbitrator thinks that they are the fairest and most impartial adjudicator, we cannot exclude the possibility of subconscious bias. And finally, I'll mention just an English case, which is the case of Sumakan Limited and Commonwealth Secretariat. And obiter in that case, it wasn't quite on point. This wasn't specifically a case about the unilateral appointment of arbitrators, but the court held that if arbitrators were to be selected from a panel and there was a procedure aimed at guarding against any... Sorry, I'm just check my quote a second. Sorry, an award passed by an arbitrator was set aside on the ground that one of the parties to the dispute, by agreement, was not consulted in the appointment of an arbitrator. Now, Justice Narasimha rightly concludes that there is a diversity of views across these different foreign jurisdictions, and so that one should be cautious about relying on them. But it does seem that the majority of cases have held, there seems to be a shared view that for one reason or another, whatever the actual analysis is, it just doesn't feel right that an arbitration tribunal should be comprised following a procedure where there has been a unilateral choice or pool of arbitrators put forward by one arbitrator. And so with that, I want to move to think a little bit more about the conceptual framework. And I think all my co-panelists have touched on this point. But if we look at the core judgment, it's very much framed as party autonomy coming into conflict with other principles. And the majority judgment very helpfully sets out the key arguments put forward by both sides in that case. And party autonomy was a real focus of the respondents' arguments. And even the court spent quite a few paragraphs of the judgment emphasizing, of course, how important party autonomy is. It's the bedrock of arbitration, as we all know, and as we've talked about for the last few days. And the way that the judgment was framed was that party autonomy was coming into conflict with other principles: fairness and equality, independence and impartiality, public policy. And I just want to raise another idea, really developing on what my other panelists have said. We all know that consent is the foundation of arbitration, and I agree with everything that has been said so far by Professor Malaguti specifically on that point. But in the common law and also in the civil law jurisdictions with which I'm most familiar, particularly in the Middle East, consent can be vitiated by a number of factors, including, for example, duress and incapacity. And I wonder if we might want to look at this issue slightly differently. Rather than seeing party autonomy coming into conflict with other principles, such as the importance of the independence and impartiality of arbitrators and fairness and public policy, I want to pick up on this idea mentioned by Professor Malaguti that when we have unequal bargaining power, and I suppose an example may be in the contracts that were the subject of core. I'm not very familiar with those specific types of contracts. Maybe we could look at this issue from the point of view that the consent for the unilateral appointment, which was included in the contract, might have been vitiated. And I think this is where Justice Pathak ended up in his presentation, that we really have to look at whether we have actual consent. And I want to just draw a comparison here because I think we have a developing other important area in international arbitration, which is international arbitration in consumer contracts. Now, as we know, in consumer contracts, by definition, there tends not to be equal bargaining power. And to protect against that, we actually have, for example, in the UK, we have unfair contract terms, consumer contracts regulations, which essentially provide that arbitration clauses in consumer agreements may be regarded as unfair inherently. The European Union goes even further and creates a presumption that arbitration clauses contained in contracts concluded between a seller or supplier and a consumer are not actually binding. And we're seeing interesting cases developing in consumer contracts when we start talking about developing digital economies. And I'll just mention two final cases on this point. And they're both cases from Canada. There was a very famous case in 2017 where it was held that an Uber driver was in a dispute with Uber, and he had been forced in his contract into agreeing an arbitration clause that provided for arbitration in the Netherlands, for which to start arbitration, you would have to make a deposit of $14,500, which I think was more than he made from Uber in a whole year. And I think the Supreme Court of Canada said that that was unconscionable. And the final case I'd like to touch on, and again, just thinking of this idea of unequal bargaining power actually vitiating consent, the final case is a case that was brought against Binance and was decided by the Superior Court of Ontario. I won't go into all of the background of the case because I know we're running out of time. But essentially, this was a consumer contract. I think the consumer had signed up to a Binance agreement on the website. And ultimately, the Supreme Court of Ontario struck down the arbitration agreement, found that it was null and void. But a feature of the case that I find very interesting is that the court noted that if you looked at the website, which was advertising for people to sign up to this agreement, it advertised that you could sign up in less than 30 seconds. And that would involve, to sign up, you would have to tick that you agree to the terms and conditions. And we all do this every day nowadays when we're signing up to digital agreements. The terms and conditions were actually 50 pages long, and the court remarked that the underlying premise of the idea that you could sign up in 30 seconds is that there would be no way that you would be reading those 50 pages of terms and conditions. So I just want to raise this idea of consent, agreement to terms and conditions, unequal bargaining power, and really trying to test this concept of party autonomy when we're looking at arbitration agreements. And where there is unequal bargaining power, do we really have party autonomy and consent to arbitration? I think we're going to see more cases in future testing all of these ideas. And we keep talking about the freedom of parties to choose how they want their arbitrators appointed. Let's just please ask ourselves on every occasion, how free are they really? I'll end it there. Thank you.
Thank you very much. Now we have very, very less time, but now we should open the floor for questions, certain questions if you want to put.
So this is a question which any of you can answer. But first, let me premise the background on which I'm asking the question. Starting from, yes, I was the culprit in first DMRC case, which Mr. Seshadri said, and then leading up to core constitutional bench judgment. There are two ways of looking at it. In Indian Supreme Court majority judgment went by constitutional principles on the doctrine of equality. that we have to have this equality, and in this unequal bargain, equality is not there where one party has to appoint, and therefore this is not valid. Whereas the two very powerful dissents by Justice Nasimha, which Sapna alluded to in great detail, that they said, of course, party autonomy, and main thing which they stressed was that we cannot bring constitutional or public law principles into this. So that is one part. We can achieve the same thing, what Sapna has mentioned, that why not look into from the prism of that unequal bargaining power, and therefore the agreement can be voided on certain grounds. And is it not a time for us or the Supreme Court, because this is Maheshwari sitting here, who is the sitting judge of the Supreme Court, that to achieve the same objective which majority wanted in court, but by adopting contractual principles rather than constitutional principles?
Dhamma, will you say? Dhamma, will you say? Or should I listen? You say, I will.
I'll respond. Thank you, sir. Even now, your Lordship's question we have to answer. I am answering. Well, I always tell one thing. Advocates think ex post, and judges think ex ante. What I mean is, the parties represented by the advocates, they come to the court and say, something has happened in the past. Please remedy that one. I don't think of anything else. Please remedy that one. This is ex post thinking. Ex ante, the judges feel, if I give this decision, it may be equitable, it may be advantageous for you. What's its impact on the future? When it comes to section 14, rather article 14, well, in this case, perhaps it may answer the need. But imagine, as the presidential position from the apex court, it trenches upon other areas where it has to be applied. Then the horizontality rules the roost. And every contract can be put to test on that grounds, and the autonomy itself gets destroyed, perhaps. So in that context, and this is called the doctrine of constitutional doctrine of avoidance. If a decision can be rendered based on a statute, reference to constitution needs to be avoided, so that that broader principle will not affect the individual cases. This is my answer, sir. Thank you.
I will add one thing and finish this because the time is over, where information has come. If we go to court to judgment, principally, then one distinction that Jhangiani said, and which we are at present in discussion, is constitutional law principles as well as administrative law principles can be brought into when there is a contractual regime. And if we look into the dissent of Justice Nasimha, he goes on the same line. When the provisions of the Contract Act and the Arbitration Acts are there available, how far we should go in that regime? That is the crux. If we see uncitral provisions, Article 16, what is that? Equality. If we go Article 18, what is the principle? If we apply those principles, in words we say the constitutional provision may not apply to this, but in principle those principles has been made applicable. And I can't say much more. You know, Justice Seshadri, that your first judgment when Article 12.5 has not been, 6A has not been brought. Prior to that, on that principle, your judgment was there. So I would not say much more. Now time is over. So sorry, please. Thank you very much.
Join me in thanking our chair and all our speakers with a warm round of applause once again, please. May I now request Honorable Mr. Justice Sachin Datta to present our chair and the panelists with a Prabhavali. A Prabhavali is a traditional ornamental arc crafted in intricate brasswork, symbolizing India's rich heritage of craftsmanship and cultural expression. Set against a backdrop of hand-woven Indian textile, it reflects the country's enduring tradition of artistry and design. We hope it serves as a meaningful reminder of your time at the Delhi Arbitration Weekend 2025. One photo, sir. One photo. That brings us to the end of this session. We will start with the next session very shortly. Thank you.